Our topic for today is discussion of the CAVC, which is an acronym for the Court of Appeals for Veterans Claims in Washington.
It's got a big name, but as courts go, it's relatively young. Is that
That
accurate?
is true. This court was established by an act of Congress in 1988, heard its first case in 1990, and has continued on from there. I think they're now up to volume 35 or so of the Veterans Appeals Reporter. I'm happy to say that my cases start with volume 2 and continue from there.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA, your guide to unlocking your VA disability benefits. If you're a veteran who's applying for VA disability, subscribe to our podcast series in order to get the latest developments in VA disability. So who are we? Well, I'm Francis Jackson. This is Christian Terrison, and we're welcoming you to our podcast series on Victory Over VA, where we talk about the various elements that go into obtaining VA disability benefits. Our firm, Jackson MacNichol, is committed to getting justice for veterans on the VA disability claims. So, who is this show for? Well, obviously it's for veterans, but not only for veterans, it's also for those who care about veterans, whether you're a spouse, a friend, just someone who is seeking to support our veterans. This podcast is for you. So having said that, let me tell you that our topic for today is discussion of the CAVC, which is an acronym for the Court of Appeals for Veterans Claims in Washington.
All right. It's got a big name, but as courts go, it's relatively young. Is that
That
accurate?
is true. This court was established by an act of Congress in 1988, heard its first case in 1990, and has continued on from there. I think they're now up to volume 35 or so of the Veterans Appeals Reporter. I'm happy to say that my cases start with volume 2 and continue from there.
Nice. Got in at the ground floor.
Pretty much.
And so what is its role in the disability claims process? Why did we think we needed a new court?
Sure. Well, here's how the thing comes about. Up until the law was passed in 1988, the VA was the only agency in the entire federal government that was not subject to court review of its decisions. Now, some of you obviously are familiar with the Social Security Administration, which manages the SSI and Social Security disability processes. Those decisions have been reviewable in the courts for, since the programs were set up in the 1950s. But VA was not. And that changed in this 1988 statute, which did a couple of things. It set up the court, it made the VA's decisions subject to court review, and it allowed for the first time for veterans to have at least limited access to attorneys to help with their claims. Prior to that, an attorney could represent a veteran on a VA claim, but compensation was limited to $10. Now, when they put that law into effect back in the 1860s after the Civil War, $10 was a good deal. But by the 1980s, not so much. There weren't a lot of things that lawyers were willing to do for $10, including pursue a complicated case on appeal. So the 1988 law changed that, and it allowed for limited access to lawyers. Back then, the rule was you had to hire a lawyer within 120 days of a decision by the Board of Veterans Appeals. Sorry, let me back up. You had to have a decision by the Board of Veterans Appeals, and you had to hire an attorney within 1 year of the date of the decision by the Board of Veterans' Appeals. And if you hired the attorney within 120 days of the decision from the Board of Veterans' Appeals, you could appeal directly to the court at that time. If you missed the 120-day mark, then basically you had to start over with a new claim.
Gotcha. And so where does the CAVC fall in the sort of appeals timeline for a benefits claim?
Sure. To get to the CAVC, there are two prerequisites. First, you have to have a rating decision. Second, you have to have appealed that rating decision to the Board of Veterans' Appeals and gotten a decision. So time-wise, unless your case is advanced on the docket, you're going to have two periods of time. The time you're waiting for a decision on the initial claim, which typically is less than a year, frequently less than 6 months for an initial claim. And then you have a second period of time where you file your notice of appeal. You have up to a year from the date of the rating decision by the regional office to do that. You file that, and then, I hate to even say this out loud, but it will typically take years for the Board of Veterans' Appeals to get to your case. If your case is expedited on the docket, that means that they'll probably get to it within a year. Now, that's expedited, understand. If your case is not expedited on the docket, you could be 3 or 4 years getting to a hearing and decision. Sometimes 3 or 4 years getting to a hearing, and then months and months after that to get the decision. But it varies from case to case. I can't give you a one-size-fits-all kind of rule.
Sure. So by the time a veteran's up to the CAVC, what sorts of issues are typically getting appealed there?
Well, there's a whole broad variety of issues that can be appealed to the court, but most commonly you're talking about service connection. The basic rule is that for service connection, you have to establish 3 elements. First, you have to show that something happened in service, an injury, an illness, whatever it is. Second, you have to show that you have a current medical disability of some sort, physical or mental. Third, you have to show generally a medical connection between what happened in service and your current medical problem. And I say generally because there is an exception. There are something called presumptions, which kind of let you jump over that piece and presume that, for example, if you served with ground troops in Vietnam, you were exposed to Agent Orange, and that presumption goes further and applies to certain diseases. So, for example, if you were in Vietnam and you now have diabetes, there is a presumption that the reason you have the diabetes is this Agent Orange exposure in Vietnam, and VA does not require you to show a medical link between your current diabetes and what happened in service. That link is presumed.
Now, I know here at Jackson and MacNichol, we have, special staff dedicated to the CAVC appeals process and, experienced with what's necessary and issue spotting and briefing at the CAVC. But how does the CAVC differ from other levels of appeal within the VA system?
Well, it's entirely different. Within the VA system, you are dealing with an administrative system that is wholly contained within the Department of Veterans Affairs. And so it doesn't require a veteran to do very much. Generally speaking, you have to submit a claim and then kind of pursue it. But the VA is obligated on its own to try to develop that claim for you, even though they don't always do it very well, and to kind of generally push the claim along. It's quite different at the court. At the court, the VA's job is to supply the court with the record. You may have seen a previous episode where we talked about the consent form that lets the VA release your veterans benefits records to the court. So what the VA does in these cases is they gather up the records and they give them to the court. Beyond that, it's your obligation to present your case. And typically that will mean writing what lawyers call a brief. A brief can be kind of a misnomer in a way. It isn't necessarily very brief at all. In fact, it can be quite lengthy. Typical briefs at the court run 10, 20 pages. Not uncommon for them to be long enough that you have to ask the court for permission to file an overly long brief. But regardless, you have to file a brief at the court. While there are special rules that allow filing of a simplified brief if you're not an attorney, by and large, at the court level, you're going to need an attorney, whether you hire an attorney or whether you get someone pro bono through the Veterans Consortium, or however you do it, you are probably going to need the assistance of an attorney at this level. The individual veteran who tries to pursue cases at the court on his or her own generally gets a bad outcome. I don't recommend that.
Gotcha. From the time, a veteran gets their Board of Veterans Appeals decision and decides to go up to the Court of Appeals for Veterans Claims, to the time the CAVC makes a decision, what's the typical time period there?
Oh, the typical time period seems to be about a calendar year. The way this works, you file your notice of appeal, and you file the supporting documents that have to go with it, and then it requires a period of time for the VA to find your actual decision, submit that to the court, and go back, pull together all your records, submit those to the court. Once that is done, the court will generally set up a conference. They have a special Rule 33 that governs these conferences, and the purpose of the conference is to try to short circuit the appeal process and get the VA to take a look at the case early on and decide whether or not it's a case that they're willing to voluntarily go back and do over. Now, that may sound odd that the agency would volunteer to go back and do the case over, but the reality is that only about 10% of the cases that get decided by the board ever get appealed to the court. So the VA has already resolved 90% of those cases as far as they're concerned. And of the 10% that do get appealed to the court, a fair number of those, I haven't checked the statistics lately, but probably 50% anyway, the VA lawyer looks at it and says, yeah, we agree that the board didn't get this right and we should send it back and get a new decision. So that's called a remand, in this case a voluntary remand, and lots of cases get disposed of that way. The ones that don't get disposed of that way are in for the long haul. The appellant, the veteran, either individually or better yet through an attorney, will file an initial document called a brief. The Secretary of Veterans Benefits will file an opposing brief, and then the lawyer for the veteran has the option, it's not required, but has the option of filing what's called a reply brief, in which he or she details the problems in the VA's response. Once the briefs are all filed, it will typically take the court a period of at least 90 days to review the case and decide how it should come out and issue an opinion saying how it came out. The bottom line in all that is that it's a slow process getting from the point at which you file the notice of appeal to the court through to the point that you actually get the decision from the court, unless you win at the Rule 33 conference and the VA agrees to remand the case. In that situation, it moves much faster.
So what are the risks or downsides of appealing to the CAVC for a veteran, if there are any?
Well, there are. There are two kinds of cases that are still going within the VA system. One is called legacy appeals, and that means an appeal from a decision that was made on or before February 18th, 2019. The other is an appeal from a decision that was made on February 19th, 2019 or later. The first group, those up to 2019, February 18th, those cases fall into the legacy category, and that means that if your case is appealed to the court and denied, then you've lost that claim. There's absent a further appeal to the Federal Circuit, that claim is done. So the risk there is obviously if you take the claim to the Court of Appeals and you lose, you have now extinguished your right to all these past due benefits that have built up over the 2, 3, 4, 5, 6 year period it took you to get to the court. However, more and more of the appeals at the court now are under the newer system, the so-called AMA, Appeals Management and Improvement Act. And in that system, you would have a decision dated February 19th, 2019 or later. And you have some options with that decision. Typically, one option would be to file what's called a supplemental claim. That just means you continue to pursue that same claim, but you submit new relevant evidence to show that the decision made by the board in that case is not correct, it's not the right decision. And so with those cases, if you file with the court, that's fine. If you fail to file in time with the court within the 120-day court appeal window, there is still the balance of 1 year in which you can file a supplemental claim on that same issue.
And before we finish up, I wanted to get to one of my favorite parts, success stories. Veterans who you've represented who went up to the CAVC and had their claims go on to be successful.
Well, there are two that come right to mind. And I say that because in my entire career, I've only had 2 cases where the facts were so unusual that the court was not obligated to remand when they were convinced the board had gotten it wrong, but they could actually reach out and reverse and order benefits paid. So in the first of those, the situation was pretty straightforward. The gentleman had a condition prior to service, was injured in service. We had argued to the court that his condition was aggravated, and we submitted a medical opinion supporting that. The VA argued that he had a condition prior to service, but it wasn't aggravated, and so he shouldn't get benefits. The judge that wrote the opinion said, look, the rule is that if there was a condition prior to service, the VA, not the veteran, but the VA is obligated to show that didn't get worse during service. And not only does the VA have to show that, but they have to show it by evidence that is essentially indisputable. Clear and convincing evidence, meaning evidence that is just so overwhelming that it's almost impossible to believe any other possible outcome. And the judge said, look, the veterans produced this report from this doctor that says, yes, it was clearly aggravated. The VA has produced this report from their doctor, which says, yeah, I don't think it was made any worse by service. But that doesn't meet the VA's burden of proof of showing by clear and convincing evidence that the condition wasn't aggravated. Obviously, there's a dispute here among the doctors, so it clearly isn't clear and convincing, and therefore the VA hasn't met their burden of proof. Therefore, I'm reversing the decision and ordering an award of benefits. And 20 years went by, and I had another case where a lady had made a claim for benefits arising from the death of her husband who served in Vietnam based on an allegation that he was exposed to Agent Orange and it caused ischemic heart failure and he died. And the mechanics are a little different, but the upshot of it was that the Federal Circuit held that this nice lady, Mrs. Rule, was entitled to not only have the case remanded, but to have the case outright reversed and benefits paid. So those are the two that come right to mind for success stories.
Gotcha.
But much more commonly, the typical success story at the court is that we go into the Rule 33 conference, we filed a memorandum explaining how the Board of Veterans' Appeals got it wrong, and the secretary's attorney comes into the conference and says, you know, we agree, the secretary agrees that the board got it wrong and we're willing to offer a voluntary remand to have it sent back to the board to do over. That's the much more common success.
Yes, and I've filled in on a few of those Rule 33 conferences, and the board's attorneys are quite reasonable, and there's typically no shortage of things to point at that would merit a remand.
Sadly, we can't do it in every case, but certainly the board, given the volume of cases that they do and the little time they have to spend on them, does make a fair number of mistakes.
It's true. So before we start making too many mistakes, that's all the time we have for today. But thank you for watching. Please be sure to subscribe and tune in next week.
We hope to see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.